Okay, so I'm going to be right outside or around the city until 5. Text me in case anything happens, okay? Whatever happens after 5.
Like everything, don't worry, okay?
Act normal. Free to the airport. Close everything, okay? And give it to whatever. Jason or someone will take them. Thank you so much.
Thank you, sure. You're welcome.
Hello. Now we are 10-12 minutes behind, late. So we'll give 10 or 12 minutes more time to the panel members to do the justice. And after that, I will learn great things from prominent speakers. Now we have 2 prominent speakers. I'm moderating this panel. And my name is Upendra Acharya. I teach at Gonzaga University School of Law as a law professor. I teach constitutional law, international law, human rights, climate change, international business transactions, and AI and human rights. So now I would like to introduce first speaker, Professore, Dr. Avocado, attorney, advocate, Ettore Maria Lombardi. So, Professor Lombardi is a professor of private law and digital society law at the University of Florence and an attorney admitted in Italy and in New York. His work focuses on private economic and international commercial law, banking and finance, and digital society law, with expertise in AI, blockchain, algorithms, the metaverse, and data economy.
Wow, you didn't know that?
But we all know that. He has worked at international firms including DLA Piper and Hayes Chahine, advising industrial, financial, and tech clients on cross-border transactions, contracts, and dispute resolution. He studied at the University of Florence and the Pontifical Lateran University, earned an LLM from Harvard Law School, and completed further studies at Oxford and Cambridge. He has held academic roles internationally, serves in governance and supervisory positions, and has published extensively, including 6 monographs and over 60 scholarly works. And in addition, that is not written here, lots of things that Professor Lombardi has done, and another his expertise that I am very much aware of is that international mediation.
Oh, wow, that's true.
And we have another prominent scholar today, our second speaker, Professor Seni Pancratius. Professor Seni Pancratius is an assistant professor at the School of Law, Christ, deemed to be Christ University, Bangalore, with an academic foundation including an LLM and a Master of Business Laws. She specializes in the intersection of international law, public policy, and social equity. She co-authored critical analysis of the National Education Policy 2020, focusing on overcoming socio-economic barriers to ensure equitable access to education in India. Her scholarship also extends into international law, energy law, space law, and legal history. She has presented her papers at various international conferences beyond the classroom. Professor Pancratius is a part of Christ University's learner-centric programs. She serves as a faculty coordinator for the International Relations and Foreign Policy Committee. And in addition to that, what we have written, I have had opportunity to listen to her presentation in Manila, in a very big international conference, and in Kathmandu, Nepal, that we organized with the partnership of the Gonzaga University School of Law. Thank you again, Jason, for that, Jacob for that, and in Kathmandu, Nepal. I have heard her and enlightened with her presentation before too. Thank you. Now welcome, let us welcome two speakers here with big clap, and Professor Lombardi, you have the forum now. The private law of democratic backsliding, tort liability, corporate complicity, and remedies against rule of law erosion.
Yes. So first of all, shall I speak here, right? Probably it's better here. Here. Does it work? Does it work? Yeah. Okay. So let's try. Yeah, always so effective. Yeah. So first of all, I would like to thank you all to be here, and I would like to thank as well Gonzaga, of course, Gonzaga University, the campus of Florence, that is a place very nice, very interesting, and very live. And I'm very proud to be here always, and honored to be here always. So today was a very tough day for me because I had many things at work in my law firm. But I said, I promise Upendra to come. I love Gonzaga University, so I will be here. As Upendra stressed before, the title of the lecture is The Private Law of Democratic Backsliding, Tort Liability, Corporate Complicity, and Remedies Against Rule of Law Erosion. So before starting, I would like to ask you, if I'm not clear, because of my Italian accent that is very strong, or I'm too fast and so forth, please just interrupt me and I will try to explain myself a little bit better, okay? So let's start with this very interesting, in my opinion, my humble opinion, quote of Nelson Mandela. So today we are speaking about human rights. I'm a private law professor and I'm a private law, a corporate law lawyer. So my position here is quite weird. So I have to find a situation to compose this mismatch, human right and private law. And so I try to understand if there is this possibility, and of course there is a possibility because private law is a very powerful tool that we can use if we open the border of this concept. And as I said, I would like to start using the word of Nelson Mandela. To deny people their human rights is to challenge their very humanity. The rights of every person are diminished when the rights of one person are threatened. So as you see, it's very important to combine tools, law, of course, tools that law provide us, and to direct them, all this toolbox, to a target that is the protection of human rights and the protection of people. Let's see if with the roadmap of today, that's the roadmap of today, we will manage to arrive to this point, and I hope that we will reach it. So I would like to start with setting the stage. So I would like to explain what is a democratic backsliding. I will explain to myself, of course, and I will be very quick. Then we will reason in terms of tort liability, then of corporate complicity, and finally, I would like to show some remedies and comparative perspectives between USA and the European Union. Well, when just to clarify one profile, now the situation is quite changed in the United States, and I'm very frank with you. I lived in the United States for many years. I consider USA as my second home, let's say it in this way. And what I always saw in this country, in your country, it was not a very open mind in terms of comparison, in terms of evaluation of other legal systems and other nations. And that's something, sorry, I noticed it, so I'm very frank. Don't hate me, but that's why the situation now is quite different because you are younger than when I was there. When I was there, it was last time for a long period, 15 years ago, and the situation was different. Now you are much more open-minded, very open to a broad experience, and so forth. So the situation has changed. But why I say so? Because in my opinion it's very important to stress a comparative profile always when we speak about law, because that's the way to understand better as well our institutions and our law. So, setting the stage, as I told you before, let's analyze the democratic backsliding. What is the democratic backsliding? So, in short, we can consider it as a gradual erosion of democratic norms, institutions, and practices. So, that's realized via three ways that I try to sum up here. So, the institutional capture. So the fact that, for example, courts, electoral bodies, and oversight agencies are conditioned in their works via pressure, executive pressure, or legislative manipulation. Secondly, but not in terms of importance, norm erosion, so the weakening unwritten rules of democratic governance, such as mutual toleration, institutional forbearance, that hold system together are less effective in terms of application and in terms of regulation of the system. And then there is something that is quite interesting. In terms of norm erosion, I would like to as well underline one profile that at least is very common in Italy. So the quality of the legal speaking. So before, so if I consider the civil code, that is dates 1942, so it has approximately 85 years, the Italian civil code, the quality of the language was very high. If we consider now the law in place, the quality of the language is very weak, is not very high, and that's something that can be considered as a way of norm erosion, because if there is no quality, so there is no punctuality, preciseness in the language, and that's the way in which we can achieve some democratic backsliding, so some gradual erosion. Then finally, I consider the weaponized law, so the use of legislation, judicial processes as a tool of repression. And we can see now these days this weaponized law as a very strong tool that is used as well in very strong democratic country as as Italy, for example, or the United States. And here I wanted to show, because being a lawyer, I don't like to speak just about theory, but I want to stress as well the practical profile. And I wanted to point out some example of this erosion of democracy. And I cited here Hungary, so where there was a successive constitutional amendments that try to reduce the independence of the judiciary system. Indeed, there was the application of Article 7 of the Lisbon Treaty, the so-called suspension clause, that try to give more importance to the judges, as well in Hungary, and also if the system, the political measures were direct to reduce this power of judges, and especially the independence of the judges. Secondly, I consider Poland as well for the same reason. So there was always a judicial reform that was creating a clash with the Charter of Justice of the European Union. And I would like to let you to underline with you the fact that very often a political system is using judges and the judicial systems to erode the quality of the democratic system. So that's something that we have to think about. And finally, the United States, where you know better than me what happened in the United States, so I don't consider this profile because I don't want to be leashed. So, if the general frame is the one that I described so far, the question that you can think about is why private law? So we have a public law system, we have rules of public law, we have constitutional law. Why we have to consider private law? Well, I would like to stress here in this slide some limit of public law. So for example, the first one, constitutional mechanism can be captured or neutralized by ruling majorities, as I said before. Then there is the international enforcement that is very slow, political very often. Why political? Because it shall consider always international convention, treaties, and often is toothless, so it's not effective really. And then there are victims of backsliding, like direct standing in many constitutional systems. So probably to operate in a way that is more proper and more effective, we have to try to sum up or to reach a point of cooperation, let's call it in this way, between public law and private law. Private law indeed is complementary, as I describe it here, and we will analyze especially tort law, because tort claims are initiated by individuals, but can have as well a backlash or an effect on the political system in general. We will see how. Then there is civil liability that creates financial deterrence, and I'm speaking especially about injunctive relief, and I'm speaking as well about punitive damages, for example. That is something very USA, so very, very important in your system. Then we have contract, a corporate law that can embed democratic safeguards. We will see how. And then private litigation that can bypass capture public institutions. So, to sum up, we have to have in mind a general and wide frame that try to combine public law and empower it via private law system, private law tools. That's the target that we have today. So let's start the part 2. We try to analyze the total liability and rule of law erosion. So I do apologize if I'm a little bit technical, but the topic is very technical. So I try to light it as much as I can. I don't know if I manage, but probably not. But yes, I want to convey some technical concept that is very important for me, and you'll see that it will be important for you as well in terms of general culture and a way to act in our society. So can tort law reach democratic backsliding? Well, if we consider the theory, the situation is quite weird. As I said, we have public law and constitutional law tools, so why we have to use the tort law? But tort law can be important both in the USA and the UE system, so the European Union system, because offer answers that can be used. And here I would like I wanted to stress some profile. So for example, the challenge of diffuse harm. So the political question doctrine, they use state liability. So this very big area that I cannot analyze with you today because the time is very limited, would like to stress how tools like tort law, and I'm speaking about damages, request of damages, for example, in wide terms, can be used to influence indirectly as well the political action. Also, we have to consider something that is very interesting in the European system, that is the Franco-Ricci doctrine. Probably you heard about it. So Franco-Ricci is a case of the European Court of Justice that involved Italy, and is a case where it was stated, so the Court of Justice of Europe stated that if there is a directive that provides and give to European citizens some rights, and this directive is not implemented in a single state, in any member state, the European citizen can use anyway the right, and if it has a damage because of the lack of implementation, it can ask damages to the government, to the specific state or the member state. In this way, you can understand easily how tort law, in terms of damages that are have been got, can be used and can be consider, as well as an indirect way to influence politics and government in terms of a much more strong democratic character. Let's consider, therefore, the intentional torts and political actors. So what are the traditional torts? I express them here. So abuse of process, malicious prosecution, intentional conflict of emotional distress. So all these situations that are composing, of course, we are speaking about as well about negligence, recklessness, and so forth. So all these tools of all these type of torts can be used, for example, by governments, like politics, and so forth, to obtain the silence of the critics. And that's why there is a very important law that was activated in Italy, in Europe, that is the Anti-SLAPP Directive. And for SLAPP, we consider, we want to describe the strategic lawsuit against public participation. So this directive try to build a mechanism that lead to a real lawsuit, to a real decision of the judge, just if there are real elements, hints that are proving the existence of torts. So why so? Because in this way, politicians or people that want to influence journalists, for example, or other politics or citizens, to avoid critics or other behaviors that are against, for example, the government, or are showing much more democratic approach, it cannot be put in silence completely. I don't know if I was clear on this point. Yeah? Yeah, good. So, let's consider then the negligence theory. As well, in this sense, there are certain actors, and I'm making reference to media companies, technology platforms, private intelligence firms, that can be considered having a real duty of care to protect the democratic institution and processes. That's something that the doctrine is thinking about. So, can we speak about the duty of care? Of course, if we consider that this possibility, duty of care, is equal to liability, to responsibilities, accountabilities, to damages in case of violation of this duty of care by the organisms that are involved in this kind of, let's call it in this way, this sort of protection. So there is a duty, there is a breach, and there is a damage that can help to change the direction of these actors that are not operating in a proper way. And yes, here I would like, I kindly ask you if you're interested to take a picture of this slide, because that's quite interesting, because in a very concise way describes the situation in the United States and in Europe. And I wanted to sum up here some main issues that are the standing for diffuse harm, the political question doctrine, the anti-SLAPP protection, the state liability for rights violation, and the punitive damages. So that's something that can be very useful for you and for your researchers. Let's consider then the second part, the third part of the speech, that is the corporate complicity in democratic backsliding. Well, I wanted to use this expression, corporate complicity, because many times it can happen, very often can happen, that companies are operating in terms of erosion of democracy without wanting it. So in a way that is not really understood, really wanted, but therefore indirectly. So there is a direct complicity that we have to distinguish from the indirect complicity, and something that is more facilitating the erosion, or that is facilitating the structure capture. And how can we obtain this situation? For sure, lobbying for the regulation, via the financing the campaigns, and via other measures and tools the company are using very, very often to promote themselves, their activity, as well in the democratic system and in the political system. In these terms, we have to consider the UN guiding principle, the UNGP 2011. Why? Because this UN guiding, let's call it regulation, is not a real legal regulation technically, but can we consider it this way to be faster. Is built on 3 pillars that are very important for the topic that we are treating. That is the state duty to protect, the corporate responsibility to respect, and the need for effective remedy. And we have to observe that also if this principle can be considered technically as a soft law, so something that is not imposing itself because it's not mandatory, at the European level and as well at the national level, and here I give you some example in Germany, but I leave you to read the technical name of the German law because it's quite long and we don't have time. I'm very able to pronounce it, but I don't do it for respect to you all. And in France, la loi de vigilance, I can speak French a little bit. So we have a practical application of this principle. And so it's for sure soft law, but it's becoming, since 2017, as well hard law, so something that is imposing itself. And in this regard, I would like just to mention the EU Corporate Sustainability Due Diligence Directive, the CSDDD of 2024, that is the last one, in terms of time, that provides a mandatory human rights due diligence for large companies. So it's something that is very important to protect human rights and to protect the position of people in terms of general rights and person. I describe very briefly the features of this directive in terms of identification of the people that are protected, prevention and mitigation, the remedies, which one are the remedies, especially remediation in terms of damages, and civil liabilities. So Article 29 creates a specific civil liability for companies that are operating against this kind of rights that are protected. But something that is very important, and we have to consider as well, are the technology companies and the platform liability. Why I wanted to stress this profile? Because I would like as well to make reference to the, I don't know if it technically is called in this way in English, the inauguration of the presidency of the actual president of the United States. You understand what I'm making reference to? So many technology companies were involved there. And we can understand why, you understood very well why as well, but I'm not criticizing anyone. I'm just, no, really, I don't have any right to criticize because I'm not in the position and I don't want at all. And I respect everyone. But I want just to analyze with you some profiles, so just as a lawyer, as a professor, and technically. So these technology companies can be very influential because they own the algorithmic power, and they give the technological power to many political actors to operate. And that is very important, always in the idea of the erosion of democracy. That's why I made here a very, I don't know if it's nice, but very interesting comparison between the US framework, so I'm making reference especially to section 213, and the EU framework, so the Digital Service Act. So the section 230 doesn't give a real protection, because it says that in general there is a kind of immunity against liability for third-party content in case of violation committed by platforms. Why so? Because this regulation is not old, but is quite old, and in that time the importance for the legislature was to protect the innovation. While if we consider the Digital Service Act, the situation is slightly different because there is not a real immunity, but there is a kind of immunity that is temperated. So especially when we are speaking about very large online platforms that are not completely protected. And so, in case of non-compliance of their activity. And this is a very major difference between the US system and the European system, and we can consider it more protective, let's say, for the human rights, the European one. It's a case. It's not always in this way. Financial sector complicity. So we spoke about the corporation complicity. Let's consider now the financial sector complicity. How it is manifested, this complicity? Via the operation of banks, investment funds, and financial intermediaries that have a really pivotal position because they are movementing and they are managing, governing the capital flows. So that's why I make reference here to oligarch financing, to ESG and governance risk. Sustainability is a part as well of the protection of the human rights that we considering today, especially in the idea of environmental social governance, and UE sustainability finance. So I'm making a very quick shift to the specific European system. Why? Because in Europe there is the UE taxonomy regulation and the so-called sustainable finance disclosure regulation that are two set of norms that are pushing companies in both banking, financial and technological sector to operate in a way that is financially sustainable and therefore protecting human rights. How? Especially via the control of the balance sheet and the way in which money are spent, are used for promoting and pushing, for example, green finance or democratic values. Let's arrive to remedies. So I know that I have something like 4 or 5 minutes, so don't worry because I will be in time. And 3 minutes. Yeah, fine. So remedies. Yeah, Upendra, he loves you very much, as you can see. And the remedies against rule of law erosion. So, which one are the remedies? We can consider them more specifically here, but I think that I told you already about them. So we have to avoid the captured courts, so the fact that the judges are limited in their operation. So there is as well a causation gaps. Why? Because if we have some indirect effect on the political system, is different, is very difficult to understand which one is the causation. So which one is the action that have created this situation? So that's a problem that we have to solve. And then there is an enforcement deficit, especially in terms of international backlash or international effects. So which one are the systems, the legal system to apply in terms of a global effect or very extended and very wide effects, negative effects, of course. So individual remedies, compensatory, as I told you before, injunctive relief. Because I want to go ahead, I would like to stress as well this profile. So structural remedies. So the fact that people have consciousness of their position, their rights, their power, and that can be manifested in the way that I described it, as well as via class action and so forth, it can push to structural remedies. And that's why a lecture like this, sorry if I appear not humble, but for me it's very important. A lecture like this is very important for you because in this way you can understand even better which one are the tools that you can use to address, to try to solve issues that are in your country or in the country where you live. So the UE rule of law conditioning mechanism, that's a mechanism that is as well impacting financially companies, but we spoke about it, that are not complying with the human rights, they don't have a human rights approach, and the strategic litigation as a remedy mechanism. So, key doctrinal challenges across both systems. So if we want to, sorry, I want to go here because I spoke about it. So I want to stress this profile very briefly and then to go to the end, otherwise Upendra will kill me. Or will poison me, probably. This is even better, but be good with a good poison. A good poison. I don't want to suffer. Yeah, I don't want to suffer, you know. My life is already a suffering. I want to suffer also in my death. So immunity and defense. So what we have to consider, and I want to stress this profile, is the fact that very often public bodies have an immunity. And so that's why it's very difficult often to influence them in terms of tort, in terms of civil law tools. But that is not impossible. We can do it in the way that I tried to describe before. And that's another profile that I wanted to tell you, the conflict laws in case of international damages, so some limit that we have to consider. So, I want to reach the point, and so I will be very quick in synthesis and conclusion with this dome that probably you know very well. Which one are the key takeaways that we have to consider? So, a tort is for sure a tool that we can use, a tort as a deterrence. There is a proper due diligence in terms of balance sheet and so forth, the companies that we can use as well in terms of ESG, sustainability, protection of human rights and so forth. EU institutional innovation, so all the rules that we have in place in Europe, they can be useful in this regard. A transnational strategy, so the possibility of operating at an international level. So here is something that I want to say to finish. A final word on regarding the law as democratic infrastructure. So democracy, that's very important, so please consider it. Democracy is not self-enforcing. So we always have to be aware of this. We don't say the system in which we live is democratic, so everything is fine. No, that's something that we have to fight every day for keeping it continuously. And today we are living a very stressful period in this regard. So we have to be conscious of the richness that we have, the wealth that we obtain in terms of morality, money and so forth because of democracy, and we have to keep it. And let me conclude with two words. One is nice and important, once again Nelson Mandela, that says it always seems impossible until it's done. So we have to push to get it. And secondly, because, so here is my contact if you want some, my contact, thank you very much, Shiny, if you want to write me or if you want to continue this discussion. But let me conclude with a motto that I want to read. They say that law is the last line of defense of democracy, which means that if you are relying on lawyers to save your democracy, you may already be in a bit of trouble. But then again, considering who is in this room today, you all, I'd say democracy's chances just improved considerably. So thank you very much for your attention.
And will your slides be available too?
Okay.
Thank you very much, Professor Lombardi, for such a illuminating presentation with a very hard topic, combining private international law and human rights in the context of executive aggrandizement and all the financial and corporate complicities and its all nuances. It's a great presentation. Now we turn to Professor Seni Pancrasius for Permanent Emergencies and Constitutional Transformation, Executive Aggrandizement, Rule of Law Erosion, and Human Rights in Contemporary Governance.
Thank you, sir.
Please.
So I have to thank Gonzaga University and also Professor Upendra Acharya for giving me this opportunity to present this paper. So basically this is a very small portion of the bigger project that I'm working on, trying to look into how the emergency provisions across the world has been changed and how this has been actually affecting human rights and also other aspects of governance. So just to begin with, I'll just give you a concept. So here The core argument of this paper is on, that is the last decade, maybe from 2014 onwards. There has been a change in governance in the international community. And so what started as a temporary process, it has now emerged into something which is permanent, and how this has got an effect on the human rights in concept as a general. So the concept of emergency, as you can see, it does not actually suspend the law. It just transforms the architecture of the governance for a brief period in time. Now, framing the problem, so on the left-hand side you can see what does it mean with respect to the traditional concept of what an emergency is. I've gone through the different constitutional provisions of most of the international countries, international communities, and I've found that 90% of the constitution has got provisions with respect to emergencies, directly or indirectly. So traditionally, the concept of emergency was temporary. It was for a brief moment of time. And of course, there was a judicial review to see if the position of the emergency was well defined with the constitutional law. But from a period from 2015 onwards, you can see that this has become an institutional process, and it has been globally synchronized. So Professor So actually displayed a small picture of the rise of few great men. So that is actually the process which is happening now. We have much more great men now in the picture. So if you look at it, just not Trump, across the world, everywhere. So as I talked to Professor Acharya in the morning, if you just come to Asia, South Asia, you come to China, you come to everywhere, you have all the rising of great men. So this is the transition which I'm actually studying into. So why is this important? So primarily, as you can see, 2014, 2015, you can see the rise of issues with terrorism, and most countries rely on the concept of internal security with respect to the importance of emergency. And then, of course, we have what is known as the challenges with respect to migrations. And then 2019, 20 onwards, we had the pandemic. And then finally, as we can see, AI comes into picture. Digital surveillance. Everything is being monitored. What do you do? Where you go? The amount of money you spend. Whom are you conversing with? Where are you traveling? So all the concept of a country, a citizen of a state, is everything is being controlled and everything is being monitored. So based on that, I think beautiful discussions we had in the morning also. So which means that there is something which is being created, that is the concept of geopolitical instability, which often creates a fear both within the state and within the citizens, trying to look into the importance of emergency and why is it important. Now, I'll just skip that. So the conceptual framework, my theoretical concept is on the state of exceptions, so wherein the sovereignty expands, sovereign authority expands their power in certain cases, right? And during that period, it could be maybe a financial meltdown or financial breakdown, and in most common aspect was the breakdown of national security or the importance of national security. And the executive aggrandizement, then you can see the erosion starts through the legal mechanisms, unlike the coups which was affected in the 80s and the 90s and even now. And now what happened is the constitutions are getting transformed. The emergency provisions are helping to change the constitutional identity as well. So therefore, my work, as I said, this is a small part of my larger project which I'm working on. So we're trying to look into the last 10 years, because when we look into the last 10 years, this is the period where the internal governance of most of the states in the world has changed drastically. So from a temporary constitutional mechanism to something which is more permanent in nature. And now the question is the importance of judiciary. Judiciary is technically seen as a watchdog of democracy. So how did the judiciary facilitate, or how did the judiciary actually resist these kinds of aggrandizement? And now the question is, can we actually go back to the concept of normalization of these emergency governance, and how does the international human rights law affect this emergency provisions? So these are some of the countries that I have focused, but I'm not going to discuss about them, because these are the countries which does have the comparative constitutional analysis which I have done. Turkey, Hungary, India, United States, Brazil, Israel, and across Europe also we can see the changes happening. So the analytical structure is, as you can see, for the from 2015 onwards, maybe around 5 to 4 years before the pandemic set in, the common excuse or the common reliance on emergency was security concept. And then we have the pandemic, which made the whole concept that it was. And then the post-pandemic, the norm continues. There isn't any kind of a question, but the whole process actually continues. So let's look into the first phase of it. Again, migration crisis, we have security concerns, and then we have the concept of terrorism, and countries that are, states that are experiencing what is known as political instability. So the real concept was, the use of emergency was to make sure that these are the drivers, and these, in order to combat them, we need to have, the executive needs to have more power. And as you can see, what these led into is most of the countries had their own anti-terror legislation expansion. And they have these concepts of preventive detention. Then all of a sudden we have surveillance infrastructure, more and more cameras. All right, so it comes in just keeping a track on what the citizens are doing, which means that we were weaning away from the concept of the right of privacy. And then, of course, the executive decree with respect to the governance. So here we can see the constitutional consequences. Security becomes a justification, all right? So which means that reliance on, or the decline of reduced transparency, and then of course we can see the expanded executive discretion towards attaining all those which are on the left-hand side of my presentation. So the next phase is something which is actually global in nature, because the pandemic, across the world, there were lockdowns, there were digital surveillance, there were closure of borders, and the whole concept of the human rights actually suffered a big breakdown during this period. And the excuse was it was the pandemic. So again, as you can see, the ordinary legislative process was suspended, and of course, exclusive powers were given to the executive because it was a pandemic, and resources were scarce, or still maybe to ration out the concepts that are given out to the people. And the main argument in the pandemic period was that during the pandemic period, the emergency concept was normalized. No questions asked. If there was demonstrations, detentions, so all these led to a new era of what was known as with respect to emergency provisions. So you can see, if we look into how different states looked into this era, you can see that generally the role of the course of the judiciary was to look into the due process, protect the fundamental rights, and have some kind of proportionality. But then that entirely shifted towards the importance of public health with respect to security, and also reliance on the executive in order to bring about a stability in the concept of governance. Now from here starts the rise of the great men. So we have post-pandemic emergency normalization. Nothing has changed. because emergency technically means that you have a sunset clause. It doesn't go on for a long period of time. It has to end, but nothing has ended. So as you can see, from the concept of emergency, which was supposed to be a short period to tide over a certain crisis, has become permanent. And nobody is actually bothered about reverting back to the real definition of what the emergency is. So as you can see, AI gets in more of digital surveillance, policing powers, and you can see national security again becomes an exception. So from here we can see that there is a structural shift between what is a normal governance towards an emergency governance, and the real definition of the normal and emergency governance is getting blurred, and the concept of emergency is now getting diluted. So here we start the whole concept, the executive consolidated power mechanisms, weaker parliamentary oversight, the opposition, all right? The role of the opposition gets diminished. The control over the judiciary, I put a question mark. And the reason why question mark is, well, how did the judiciary react to such an executive, aggrandizement? And of course, data surveillance increases, and also the concept of national security is still being held down for a big period. So as you can see, what from here is the changes with respect to the democratic impact. Constitutional accountability is being weakened, and electoral democracy is still strong. So people who challenge, as I said earlier, detention, okay, no questions asked. And this is, as I was telling Professor Acharya, is there all around. You know what I mean? It's just not focused on any one state. It's all around. And this is where we have the connect to our main theme of the conference today. What are the rights that are affected? No freedom of expansion. The moment, especially from South Asia, if there is a freedom of, if somebody makes a statement, he's being treated as, someone who works against the national security of a state. Lack of privacy, freedom of movement, assembly, due process rights, all these have been affected. And who are the people who are affected? The minorities, the migrants, the journalists, the political dissenters, the media, and also the civil society groups. So, international human rights law. So we do have concepts within the international human rights law. And of course, the international human rights law talks about the strategies that has to be, safeguards that has to be implemented to maintain erosion of human rights, necessity, proportionality, and also the non-discrimination. But what is emerging is the continuous aspect of emergencies, and the crises do not end within the borders of a state. It is becoming transnational. Everything is, I think that is what Immanuel Kant once upon a time said. Something happens in one country, affects the whole country. So the whole entire global community is being engulfed into it. And the end effect is each of them, all of them, are actually being normalized globally. So the question is, how do we reclaim the concept of constitutional accountability? Every constitution has got sunset clauses. Every concept, the judiciary calls for this independence, but the question is how independent they are. And the transparency with respect to emergency criteria, all these existed before. But now with the sudden change and the concept of human rights centered proportionality, how does it affect? So this is the part of where I said. So 2015 to 2025, the concept of emergencies no longer become an interruption to the governance, and actually the emergency itself defines how the governance system works. So therefore, the gradualization, as you can see, the normalization of this process as we move forward. One example is with respect to Trump's actions, which Professor Acharya talked about in the earlier part of the day. So some of these countries which I have carried out my research on, Turkey, right? And also with respect to India, Pakistan, Bangladesh, Sri Lanka, all of them, they're changing. Vietnam, China, so all changes. Europe. Yes, so all these brings us to a critical situation because emergencies become the norm. And especially Mr. Trump goes to Venezuela, takes the president of Venezuela, goes back to the country, and nobody made any noise. That's what actually, shocked me. At least there should have been some noise, right? You go to a foreign country, you take the head of the state, take him back. So that comes to mind. It's a bigger project, so I'll take some discussions from you all so that I can see what can happen.
Thank you, Professor Pancratius. It's a wonderful, again, presentation. So this panel is a combination of public law and private law, and getting to a common feature and common points on liability, accountability, and responsibility for not complying with due diligence in terms of corporate government relationships, and as a matter of soft law guiding business and human rights as recorded in the Remedies report, the Business and Human Rights Remedies report, and to a constitutional structural shift from normal to emergency governances. I think this is a great presentation. I would like to welcome some comments and questions to the speakers. Such a wonderful presentations. Any questions or comments, please?
Thank you so much. My name is Lydia. I had a question regarding tort law as a remedy and what that might look like. You may not be aware. Recently, the last couple of days, Forbes published an article about discussing Trump and his economic windfall that occurred in his first year in office, estimated over $1.5 billion through cryptocurrency and other ventures. And so I offer that as context. And then from the perspective, a lot of us are 1L students, so we just went over our first year of con law. And the United States, this isn't a new concept for us. Since the mid-50s, we've had this lens of when is the president most strong in his actions, when he's working with Congress, when he's working without Congress, or when he's in this twilight zone where there's silence from Congress. Since then we've had, and it's not isolated to Trump, since then we've had Clinton, we've had several different opportunities of American executives who have pushed this ebb and flow. And so we've had a consistent line of theory through the American judicial system saying that in order for there to be a check and balance, in order for there to be effective democracy, the executive as a sole individual, a sole arbiter, needs to have this immunity in order to operate effectively. And so the ability for tort law and other types of litigation has been reduced depending on whether or not he was acting in private capacity, whether he was acting in official capacity, etc. Whether it occurred while it was in office, whether it occurred while it was out of office. So I'm wondering, considering this and considering, the recent economic news, is there a lens in which to view this expansion of executive power not from a democratic backsliding, but from a democratic strengthening when there is a system that requires stringent checks and balances and strict independent branches with no overlap. Immunity for an executive could be viewed as a democratic strengthening instead of a democratic backsliding. Is that an effective lens, and is it simply Trump as a specific case study that is abusing it, or is it a systematic issue in the American judicial system?
So, what's your name? Once again? Lydia, that's a beautiful Greek name. So Lydia, well, that's your question is very interesting, very clever, very smart. So thank you for it. Well, I would like to ask you one thing, by the way. What's up?
In the center, the video will capture you there, if you are in the center.
Ah, shall I be here? Okay, okay. Ah, the camera, sorry. I didn't think about it. Sorry. Yeah, you're right. Yeah, you're right. I have to sit as well. Lydia, hi. So she won't see me anymore. So she doesn't lose anything, but you know, for respect. Okay, so Lydia, no, it's okay. So what I would like to ask you is, I read in the newspaper something like 2 days ago, 3 days ago, that there was a clash, a claim, basically, technically, between Trump as a person and a tax agency in the USA. And what happened? That they reached an agreement according to which Trump will be safe also after his mandate. Is it true? Yes. Yeah. I'm asking you, do you think that this kind of agreement is responding to a check and balance measure, a check and balance interest, importance, system, and so forth? Well, I don't want to, I'll give you my idea, okay? You tell me yours, of course. In my opinion, your idea would be great if this agreement had a very limited time frame, and therefore Trump would be free to be under the power of the tax agency after his mandate, but he's not. So your thought is very interesting. I like it because it's another way of looking at the things. It's less problematic, let's say. It's shifting the view. But in my opinion, the trend is to change completely this check and balance situation. And I can tell you, in Italy, in Europe, US is viewed as a symbol, and a very important symbol of check and balance measure and democracy. And in Europe, the most old democratic system is the UK one. Both in the UK and the USA, Anglo-Saxon countries, there is a crisis in this sense. So we are living a very strong crisis of the check and balance situation. So probably I consider it a crisis of the democracy in general. Why? Because democracy failed. If you see, it's not very effective. Because if you consider the situation that we had in Italy, I'm speaking about Italy because it's my country, you are here now, in the 50s and now, so the power of the parliament was much higher in the 50s and 60s and 70s. Gradually, what happened? That it was this power ineffective because every decision took a lot of time, especially in a moment in which you have to be fast. Word is super fast. That is negativity, it's something negative, but it's in this way. So that's why the government are taking more power and they will take more and more always. And what is the solution? The solution is to try to check and balance, that's to balance this need of effectiveness with the respect of the human being. Because what Shining is saying, so for example, the fact that it could be a crime, could be, I don't know who, this Maduro, right? But he was always the prime minister of a nation. So in the 70s, for sure, in the 80s, in Italy, in the USA, there would be a mess of young people shouting against the situation. But didn't happen anything. And the same will happen in 2 months in Cuba. Because already in Cuba, now they are preparing everything, and there will be, and no one is saying anything. And Nimitz, how is it called, the ship, Nimitz, arrived to the Caribbean Sea 2 days ago. So they are preparing everything. Who is saying something? No one. That's weird, right? So it can be a trend, what you say, but it's a problematic trend, probably. I don't know if I answered.
Great. Do you want to answer to that, or that is good?
Yeah, that's, I mean, sir said what I want.
Okay.
So Cuba is one,
Okay, sorry.
and again, when you look into history, North Korea has got nuclear weapons, but Trump doesn't want to go to North Korea. But all other states are just suspicions they may have weapons of mass destruction. But going forward, these are, examples wherein nobody is reacting. Greenland was one issue.
Absolutely. I didn't think about it.
Yes,
You're right.
yeah, Greenland was one issue. And again, the main intention of the US to go to Iran was the oil reserves, but somehow we didn't. Previously, as I told Professor Acharya, we had just one protracted war, Ukraine versus Russia, but now we have three. So it's actually increasing,
Thank you very much. I think that Lydia's question, one question part that whether only this administration, Lydia, only this administration is the reason, or has there been any systematic structural shift in the United States history? I think, if I remember correctly, the last Professor Rooksby, Ingasso, Cecile, and Professor Noon, everybody is here, Michael DeLucia, Fisher, all of, please, I'm wrong, please correct me. The first time when the American president, who did not go to Congress to declare the war or to approve the war, and exercised war and emergency power, was the President Truman during the Korean War. That unleashed that practice and set the precedent. And since then, the presidents in the United States have been ups and downs, have been time to time exercising war and emergency power without going to Congress, and it has become a big structural shift in our constitutional practice, and has become an example of executive aggrandizement since then. Vietnam War, the 1964 war resolution gave so much power, and after that, 1976, that War Power Resolution, War Power Act was done by Congress, and after that, everything that President Bush did, that in Afghanistan and Iraq with the AUFM, but President Obama went to Libya and Syria without congressional approval. President Trump has gone to Venezuela, or Caribbean, to Cuba, and all those things, and Iran without. So there is a kind of practice and toleration of a structural shift by American legal scholars and judiciary on this matter. If I'm wrong, please correct me. Any other question? Oh yes, Professor DeLucia.
No more.
I really admire the way the panelists describe the lack of accountability in the political world over the last few years. But I wonder if you could just say a comment or two about what's been happening in the corporate world in the last 10 years. In the 1990s, there were 8,000 for-profit corporations registered with the Securities and Exchange Commission. Today, that's no longer the case. There are only about 4,000. And the reason they no longer register with the Securities and Exchange Commission is if you are a corporation like Ford Company, you have to submit audited financial statements. You have to allow shareholders to vote. Elon Musk was sued by his shareholders successfully for nearly $1 trillion. You have to submit to the governance and the scrutiny of the Securities and Exchange Commission. Today, that is not happening. The number, as I said, went from 8,000 to 4,000, and there is no accountability for those 4,000 that left, because there is so much credit being offered in the private credit world that they don't need to register with the SEC anymore. And the same thing is happening with insider trading, which is so prevalent. It always has been prevalent in the United States. The government, the Trump government, President Trump, they completely eliminated the Consumer Financial Protection Act, which only had one objective, and that was to protect us all from the collapse that happened in 2008. It's gone. And they cut the budget for the SEC, whose job it was to protect us from insider trading. So my question basically is, you describe the erosion of accountability in the political world very, very well. Can you say a few words about what you may have observed in the erosion of accountability in the corporate world?
So, what's your name?
Sure.
But is it for me, the question, right? It's me?
Whoever has the right answer.
No, well, I have my answer. I don't know if it's right, so.
We're going to grade you on your answer.
Okay. So do you want to know first? No, you, I'm in charge. Oh, you,
Yeah.
are you sure? I will do, okay. So, what's your name?
Michael.
Michael, so thank you for the question. It is very, very complex and very nice. I would like to answer in a very short way. Money. So everything is related to money. So how can you silence the corporation, people, shareholders, stakeholders, every holders and so forth with money, dividends and so forth. So that's why. So we created a world, and I'm a part of this world because I'm a lawyer, so I'm very connected with money, and I like the money as well. I'm not a Jesus Christ, oh, everything is beautiful and so forth. I want to live as a poor guy. No, I'm not. Because I want a couple of Ferrari, I want a Rolls Royce, I want a villa up and down, you know. But everything is related to this. So as soon as you make money going around, there is a lack of accountability in general, as well inside corporations. That's very simple. It's not a bribe. Are mechanisms that are inside the companies that help to achieve this level and to silence the people inside the company. So I'm very straightforward and very specific, but you know what I mean. That's my answer. It is not the right answer. Michael, I don't know if you are satisfied.
Do you want to make a short answer, Professor Brennan?
No, basically I think the corporates, they do have a say in the government, to some extent. So I think there is, the policy decisions do tend to favor the people with money.
Yeah.
Yes. So it tends, yes. I don't think we can separate them both, there will be some form of, as Sir said, it's not entirely about bribe, it's about maybe, just giving them some kind of support, especially when elections are near. Yeah.
So thank you very much. Any other question here?
So that,
Please.
yeah.
Thank you. Oh,
Yeah, she was
here.
the first one.
You go first.
She had first raised. And then,
It's okay.
yeah, let us keep it a little bit shorter now because we are 15 minutes late. So I will, this 15 minutes more, so it's 5:30. We're gonna like that. Okay.
So first question I have is for you,
Thank you.
and it's about, you said you've got the idea of like using torts to enforce privately laws protecting against democratic erosion. Are there any laws in particular you think would be helpful to be passed, like in like anything prohibited or like some kind of, what is your thought process for that? And my question for you.
I'm sorry, didn't understand very well, sorry. What is my fault about? Sorry.
What specific kinds of laws do you think, like what prohibiting or penalties in particular do you think would be effective? Like
Yeah, but
for
which
certain-
kind of law in the USA, in the Italy, so a specific law or?
Any law in particular you think would be protected? Like for Italy or US, what kind of law would you, if you had to pass a law, what would it be?
Okay.
For the torts?
Okay, I understand. That's it? Okay.
Well, that was one for her, which was what she thought.
There is another,
Oh.
yeah, sorry, yeah, there was a second question.
Short and slow and please, yes.
Sorry, I was trying to work fast because you're short.
No, it's my fault.
My second question would be, I think sometimes the executive branch takes advantage of emergencies. Do you think there's any possibility of like a way to restrict their ability to declare an emergency? And once there is an emergency, have someone say, okay, it's over, so they can't keep taking advantage of the situation.
Thank you, Ivan.
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 Yes.
Ivan. So Eva, thank you once again. So the question is very articulate as well in this case. You are very articulated people, I have to tell you. By the way, which kind of law? For sure, very important would be the function of agency. So the independent agency. Why? Because they are supervisors, and they have the possibility and the power to control the different part of the market. So, for example, finance, SEC, for example, FSA in the UK, and so forth. So, power of the agency, so to control the operation, and operate in terms of accountability. Not so much of liability, but in terms of accountability. Because accountability combines the political position and the technical position. So you are involving in a process of accountability both the government, the parliament, and technical people like the agencies. So I cannot give you now a formula. I would use this law, but for sure, in terms of accountability, I would consider agencies, parliament, so the political power.
No,
I finished.
Go ahead, go ahead.
Yeah, political, I finished. And to act as well in terms of threshold of accountability and liability. So recklessness, for example, they hire, as well as some kind of negligence as well, but not to put them too low as a level of liability, because otherwise you are paralyzing completely the market and you are completely paralyzing the operators. So you have to balance, as Lydia would say, check and balance the situation, the system. Okay? Thank you.
Okay, there is, yes, the answer, and we have very short 2 hands raised here. Still, we gotta go.
Sorry.
Yes, sir. No, that's good. No, great.
Yes, ma'am. So the question you asked is how can we, contain the user? No, there has to be a sincere effort in the governance itself. Say, for example, when Trump came to power, there was an ad that came out. You can get you onto a cruise and you can come back to the US after 4 years. So that is the concept. So it is the effort that the state has to make sure. That's what I mentioned about the sunset clauses. So which means that yes, there are sunset clauses, but it is not being followed because power. So once you get into the concept of having power and then, getting all what you desire in the administration, the governance, it then becomes a problem.
So, Professor Cruz,
Thank you so much for the panelists for this amazing session.
as short as possible.
Yes, a short question to Ettore in relation to business and human rights aspects.
Yeah.
Very simple, you've mentioned, of course, the UN guidelines. Do you see any prospect for international or regulation or convention, something harder coming in? Because I work on illicit antiquities markets and trafficking. And my dream was that business and human rights could be applied to auction houses, for instance, and the biggest markets are US and UK. So can we foresee in the near future anything stronger coming also on international stage? And will it ever include auction houses? Because you spoke large companies. What are large companies, and if there will be any?
Okay.
Thank you.
So thank you very much. So I will be very frank with you. So in my opinion, it's not a case to increase the quantity of regulation, principles of law, but to apply it. So I was in the United Nations, months ago I was invited in Geneva, and we were speaking about consumer protection. And there was an Indian professor, no, he wasn't an Indian professor, he was the chief of the antitrust competition agency of India, that said, we have to protect the women and we have to create a treaty just to protect the women. And I fully agree with it, but, and kids as well. And I said, sorry, but what about the Treaty of 52 that is protecting kids and human beings and so forth? We don't need to multiply treaties, conventions. We have to apply them because that's important. Otherwise, blah, blah. So, sorry, yeah.
Thank you. Now we have another question from Michael, and then very short. It is going to be very short. Please, one last question. Is that okay?
But
For you panelists?
Sure, absolutely.
This is a very quick question.
Michael, you once again.
You mentioned money, so my question is about Italy and France and Germany. The United States has a whistleblower statute. The United States government will pay you enormous amounts of money if you will blow the whistle on a colleague or a corporate executive who is engaging in insider trading or naming a corporation that is defrauding the government. The government of the United States paid $104 million to an American banker who blew the whistle on UBS, United Banks of Switzerland, because he handed over a disc with the names of 19,000 Americans who were cheating on their taxes. Does Italy have since you're interested in money, does Italy have a statute, a whistleblower statute? And if it doesn't, why not? France has a whistleblower statute, but they will not pay you if you blow a whistle.
Yeah.
They will just say, thank you. You risk your job by doing that, and they won't pay you. What does Italy do?
Michael, so nice question again. So we have a regulation that is a European regulation, so it's applicable at all Europe. And I can tell you, because I'm the president of the supervisory board of an American company, probably you know Baker Hughes, you know, General Electric Oil and Gas was sold to Baker Hughes, and now it's a huge company that is producing turbines, basically. So the problem is that we have to apply the regulation is the data protection and privacy. So because people are giving information, but we are creating channels to protect their privacy completely. So it's not a matter of money that we don't provide, we say thank you, but the problem is how to protect them to avoid any consequences, and as well to avoid that they can say something that is not real, you know? I would say, but we cheat at the end, but you understand what I want to mean, right?
It's always about money.
Thank you, Professor Lombardi. Now I'm going to get this mic to Professor Sam Newton, that how he observed all this conference all the way, and a very conscious observer, and as a conscious observer, please let us know how the conference went. Very short, we have very short time, but still I would like to request you.
Thank you.
Do you want me to go to the camera?
Yes, here.
You do.
Also, I can trade that out. Okay, thanks. So Robert Bolt wrote a play in the 1950s. It was called A Man for All Seasons. It became a major motion picture in the United States in the 1960s. It's about the true story of Sir Thomas More, who was the Lord Chancellor in England, to Henry VIII. Henry VIII wanted to, now there's a scene kind of early in when a young law student comes to Sir Thomas More, and he basically is trying to schmooze for a position. And Sir Thomas More rebuffs him and says, no, I'm not going to do that. And Sir Thomas More's son-in-law says, you should arrest that man. And he says, what law has he broken? And he says, well, now you're going to give the devil the benefit of the law? And he says, yes, what would you, Sir Thomas More says, yes, what would you do? Cut a great road through the law to go after the devil? His son-in-law says, yes, I would cut down every law in England to do that. Then Sir Thomas More says, oh, and when the last law is down and the devil is turned around on you, where would you hide, Roper? All the laws being flat. This country is planted thick with laws from coast to coast. Man's laws, not God's. And if you cut them down and you're just the man to do it, do you really think you could stand upright in the winds that would blow them? Yes, I'd give the devil the benefit of law for my own safety's sake. Now, More later describes the law this way. He says, the law is a causeway upon which, so long as he keeps to it, a citizen may walk safely. Now, later, Henry VIII wants to get a divorce from his wife to have a male heir. And he asks everyone in his court to sign an agreement that they are okay with the king getting a divorce. And More says, I'm not going to sign. And I'm not going to say why. And he says, my safety is in law. And everyone says the king imprisons him, strips him of his title, and says, all you have to do is sign a decree and you're out. This is a true story. And Moore's like, I'm not going to sign. And I'm going to be silent. And he goes to the court, and they say, of course you're refusing to sign because you don't agree that the king is going to have a second marriage, or another marriage. And he says, no, Master Secretary, qui tacet consentiere. The maxim of law is that silence equals consent. So if I have chosen silence, the law protects me that with my silence, you can construe legally in a court of law as agreement. I have my own reasons for why I'm choosing to stay silent. Well, the court says, nice try, and they execute Sir Thomas More. Now, the interesting question that I think to ask here is More chose silence as his safety. And there's a great Polish thinker who gives an illustration of a grocer who puts out in front of his store, "Workers of the world unite." And he says, he doesn't believe in the slogan, but he puts it in front of his store so that everybody can agree with it and see that he agrees. But what happens, he says, if one day he takes down the sign and then he starts to speak his truth to people in power? Sir Thomas More thought his safety was in silence, and it killed him. The safety, I believe, is in speaking, and speaking our truth and refusing to be silent. So my observation with those two anecdotes is that what we have been doing in this conference, and what I have heard, are people speaking truth to power. And when we speak truth to power, a system that thrives on lies and a system that thrives on its own hubris cannot withstand the truth. And that would be my reflection.
Thank you very much,
Yes.
Professor.
Thank you.
Now, I will not say anything other than thanking all the speakers and then get ready to have fun. We adjourn this conference. Thank you.
So can you give me